Hello and welcome to Courts This Week by LiveLaw, a roundup of everything that made headlines in Indian courts over the past few days. I'm your host Debojeet Das, and with me today is Advocate Awstika Das, here to help us understand the law better.
Thanks, Debojeet. Over the next few minutes, we'll be discussing some key developments from the courts. First, we'll have Umar Khalid's bail plea, which has reached the Supreme Court again. We'll then move to the presidential reference on the governor's power. In the docket, we have a plea to cancel the India-Pakistan Asia Cup match on Sunday and much more.
All right, let's start. I think the most important issue from the week is the Umar Khalid bail matter, which has reached the Supreme Court again. This week, a bench of Justices Arvind Kumar and N.V. Anjaria deferred the hearing in the bail pleas of activist and UAPA accused Umar Khalid and three others in the Delhi riots larger conspiracy case until September 19th. The reason for this delay? The judges said that they received the files only at 2:30 a.m. the night before, making it difficult to proceed. Awstika, this case has been pending for almost 5 years now. That's half a decade. And Umar Khalid and the others have been in jail in connection with it too. What does that mean and what does that mean for the accused, and what the larger question?
In this case, charges haven't been framed yet, even though Umar Khalid and the others have been in jail since 2020. So you're right, that's almost 5 years. This has brought back the debate about whether the process itself ends up becoming the punishment, as the Supreme Court has flagged in a number of cases. We've seen similar concerns raised in cases like Bhima Koregaon Elgar Parishad, where activists and terror accused Vernon Gonsalves, Arun Ferreira and Rona Wilson and others spent years behind bars before finally getting bail. In some cases, we've also seen that despite the accused being behind bars for several years before or during trial, the matter ultimately ends in an acquittal, meaning that they are found not guilty. Of course, we are seeing this rhetoric branding Umar Khalid and others as anti-nationals who should remain behind bars. Some go further to argue that when the allegations involve terrorism, riots, or national security, keeping the accused in custody is necessary to protect society as a whole. But the Supreme Court, Debojeet, has repeatedly said that keeping people in jail for years before their trial is a violation of their right to personal liberty under Article 21 of the Constitution. The court has also made it clear on multiple occasions that even strict bail laws like UAPA, PMLA and NDPS must give way if there is an inordinate delay in trial. And don't forget, this has been a long journey through the courts. Their bail was first rejected by the special court, and their appeals have been pending before the High Court since 2022, and for Umar Khalid and Miran Haidar since 2024.
Here I would like to bring your attention to another case in which Justices Pardiwala and R. Mahadevan observed that such applications which directly concern the right to personal liberty cannot be left pending for years while the applicants continue to suffer under a cloud of uncertainty.
Good point, Debojeet. The Supreme Court has passed very important directions in this case you're talking about, which is Anna Vaman Bhale Rao versus State of Maharashtra. While it upheld the Bombay High Court's rejection of anticipatory bail to three accused in a land forgery case, it pulled up the High Court for keeping their bail pleas pending for 6 years. Imagine. Their applications were filed in 2019 and kept pending until 2025. Importantly, a bench of Justices J.B. Pardiwala and R. Mahadevan have now directed the High Courts to ensure that all bail and anticipatory bail applications pending before it or before subordinate courts within their jurisdiction are disposed of quickly, ideally within 2 months from the date of filing. This, in my opinion, is a major development, and if implemented properly, this could be a big step in ensuring that years of liberty are not lost before a trial even begins. However, I must point out, Debojeet, that some commentators have noted that while the Supreme Court routinely stresses speedy disposal of bail applications, there remains significant inconsistency in how bail pleas are prioritized and decided across different cases.
Next up, finally, Constitution Bench of the Supreme Court has concluded hearings on a presidential reference concerning whether governors can indefinitely delay assent to bills passed by state legislatures. The centre argued that while governors cannot sit on bills forever, the Constitution does not specify deadlines either. It admitted such delays can disrupt governance, but stopped short of supporting a fixed timeline. With multiple state center standoffs in recent years, particularly in opposition-led states, the Supreme Court's upcoming verdict could redefine federal balance and legislative accountability. So, Awstika, what do you know about this and what can we expect?
I've been following this case very keenly, and the hearing went on for 10 days. This presidential reference goes straight to the heart of center-state relations. But first, what is a presidential reference? Under Article 143 of the Constitution, the President can ask the Supreme Court for its advisory opinion on questions of law or fact that are of great public importance, and the court's answer, though not binding, carries high persuasive value. Now, in this case, the Supreme Court has been asked to clarify what exactly a governor or the President can do when a bill lands on their table under Articles 200 and 201 of the Constitution. What options they have, whether they are bound by the advice of the Council of Ministers, whether their decisions can be challenged in court, and crucially, whether courts can prescribe timelines to stop them from indefinitely sitting on bills. The reference also asks if Article 142 can be used to fill constitutional gaps and whether courts can examine a bill before it becomes law. Several opposition-ruled states, Kerala, Tamil Nadu, West Bengal, Karnataka, Himachal Pradesh and Punjab, argued that a governor cannot have a free hand. They must either grant assent or send the bill back with reasons. Giving them unchecked discretion, they argue, would paralyze elected governments. These concerns are heightened by the fact that many governors in opposition-ruled states have ties to the party in power at the center. On the other hand, states like Madhya Pradesh, Maharashtra, Rajasthan, and the union government have argued and supported a wider view of gubernatorial power. They say governors need room to act in rare exceptional situations, even if that means withholding assent without explanation to protect constitutional balance. Anyway, the bench has now reserved its judgment, which means that the hearings are over and the verdict will be delivered later. For now, we wait. But whenever it comes, this decision is almost certain to be a landmark moment for center-state relations.
Moving on to another notable story this week, as the Supreme Court also questioned why only bureaucrats decide compensation for land acquired under the National Highways Act without any judicial oversight too. Awstika, as far as I understand from the hearings and in past rulings too, the Apex Court has consistently upheld fair compensation to landowners, including solatium and retrospective interests.
That's right, Debojeet. Article 300A of the Constitution says that no person shall be deprived of their property except by authority of law, which means that if the state takes your land, it must do so fairly and by following due process. The right to property is a very important right in our constitutional framework, and at one point of time, it even used to be a fundamental right under Article 19(1)(f) before being moved out of Part 3 by the 44th Constitutional Amendment in 1978. Now, even though it's not a fundamental right anymore, it is still protected as a legal right under our Constitution. In this case, the Supreme Court pointed out that the National Highways Act 1956 permits bureaucrats, not judges, to decide how much compensation is owed to a landowner whose land is being taken by the government, unlike the Land Acquisition Act where there's judicial supervision. This challenge comes from a Punjab and Haryana High Court judgment striking down sections 3G and 3J of the Act as discriminatory because they deny landowners benefits like solatium, which is an extra 30% compensation, and statutory interest available under the 1894 and 2013 land acquisition laws. Thanks to the court, the bench of Justices Suryakant and Joymallo Bagchi highlighted the need for some independent judicial scrutiny and has asked Solicitor General Tushar Mehta to get instructions from the union. This case is still in progress and we'll have to wait and watch how the government responds.
Moving to a story that grabbed a lot of attention for its timing, a public interest litigation was filed in the Supreme Court this week seeking cancellation of the India-Pakistan Asia Cup match scheduled for September 14th. The petitioners, they're 4 law students, according to them, allowing India to play in Pakistan so soon after the Pahalgam terror attack and Operation Sindoor sends the wrong message. It undermines national security too and hurts the sentiments of victims' families. But the Supreme Court did not actually see any urgency. A bench of Justices J.K. Maheshwari and Vijay Bishnoi said it's a match, let it be. Match should be going on, and refused to list it on priority. Obviously, a sensitive issue for many in our country. What are your thoughts about this, Awstika?
Outside the courtroom, the match has actually managed to really divide opinion. Many fans say it's too soon after the conflict and have called this insensitive. Some even accuse the BCCI of putting profit over principle. Others argue that cricket has always been a bridge between the two countries and that politics shouldn't mix with sport. Cases like this in the courtroom always spark a bigger question about the scope of judicial review. Should courts step in and stop a cricket match just because there is public outrage by some sections? Or is that a line better left to policymakers and sports bodies? Let us know what you think in the comments below.
An interesting turn of events and a positive one for medical professionals, the Supreme Court this week ruled that the NCDRC wrongly awarded a 10 lakh rupee compensation by inventing a case of prenatal negligence. But that was not even on the case complaint. The original case was about postnatal care after a woman died of postpartum hemorrhage. The top court said you cannot build a new case during appeal. Courts must only restrict themselves to what has been argued before. So, what can you tell us about the judgment, Awstika?
Debojeet, what the Supreme Court basically said in this case is this. The complainant's entire case was about negligence after delivery, not about care during pregnancy or before delivery. The NCDRC, however, shifted the focus completely to pre-delivery prenatal care and found fault with the doctor for not getting certain tests done. The court said that once the NCDRC had itself concluded that there was no negligence in the delivery or post-delivery treatment, which was the complainant's actual case, as you pointed out, it had no business creating a new case about prenatal negligence on its own. Doing that, the court said, went beyond its powers and violated a very basic rule. No court or tribunal can decide a case on grounds that were never pleaded or argued. This is why the 10 lakh rupee compensation, which was based entirely on this new antenatal negligence theory, had to be set aside and refunded.
The Supreme Court this week upheld FIRs against former senior CBI officials, including Neeraj Kumar and Vinod Pandey, accused of misconduct in cases dating back to the early 2000s. Allegations include wrongful confinement, evidence tampering, and coercion, with the court holding that even a CBI preliminary inquiry cannot override judicial directions when serious charges are involved. It's a strong message. No one is above scrutiny, not even those investigating crimes. So, what do you think, Awstika?
What makes this case significant is that the Supreme Court made it clear that a preliminary inquiry report, like the one filed by the Central Bureau of Investigation, cannot stop a constitutional court from deciding that a cognizable offence is made out and directing registration of an FIR. Accordingly, the Supreme Court upheld the Delhi High Court's direction to register FIRs against the former CBI officials with a key modification. This probe will now be conducted by the Delhi police rather than its special cell, which usually handles terrorism cases. It also said that the CBI's preliminary inquiry report may be considered by the investigating officer but cannot be treated as conclusive. Importantly, the court directed that the investigation will be completed promptly, ideally within 3 months.
Next, we need to take a look at the big update from Supreme Court. This week, on the written recommendation of the Supreme Court Advocates on Record Association, the top court has now officially banned photography and videography from inside the high security zones, except for official purposes, of course. This new circular applies to everyone: advocates, litigants, interns, law clerks, even media personnel. No more reels, no selfies, no casual video recordings inside the high security zone. Media interviews and live broadcasts will still be allowed, but only at the designated media lawn in low security zones. And for those who break the rules, the circular is very clear. Bar associations and state bar councils will be asked to take action against advocates, while media personnel can have their access suspended for a month. As someone who frequents the Supreme Court a lot, what do you think of this, Awstika?
Honestly, Debojeet, I think this was bound to happen. Over the past few months, the Supreme Court lawns have turned into something of a backdrop for reels, vlogs, and photo shoots. And not everyone was happy about it. The Advocates on Record Association even wrote to the Chief Justice and even the Supreme Court Bar Association passed a resolution calling for stricter rules and their implementation. This circular now makes it very clear. No reels, no casual videos, no photos inside the high security zone, not even in the lawns unless it's for official purposes or by media personnel. And yes, if you break the rules, there could be consequences, like you pointed out rightly. But here's the bigger question. Social media is now such an inextricable part of our lives. Even senior lawyers are posting reels and trying their hand at influencer style content. I've seen lawyers post orders on LinkedIn to celebrate their victories. So, where should we draw the line? Should the court be completely off limits? Or is there a middle path where content can coexist with the dignity and security of the institution? Tell us what you think in the comments below. We'd love to hear your thoughts.
Now to the Bombay High Court, where families of victims in the 2008 Malegaon blasts are challenging the acquittal of Pragya Thakur, Lieutenant Colonel Prasad Purohit, and 5 others. The special NIA court had acquitted all 7 in July this year, citing lack of evidence, forensic lapses, and even tampered witness statements. Unconvinced, these 6 family members, including Nisar Ahmed Sayyid Bilal, have now moved the High Court. The appeal is expected to begin on September 15th. And what can you tell us about this, Awstika?
A little bit of context, I think, is important. During the 2008 Malegaon blast, a bomb strapped to a motorcycle exploded near a mosque, killing 6 and injuring over 100 people. The Maharashtra Anti-Terrorism Squad, led by Hemant Karkare, said Pragya Thakur, Lieutenant Colonel Prasad Purohit, and others plotted the attack through a right-wing group called Abhinav Bharat to target the Muslim community. Later, the NIA took over and in 2016 dramatically dropped charges against Pragya Thakur, even accusing the ATS or Anti-Terrorism Squad of coercing witnesses. But the trial court refused to discharge her. After years of trial, the special NIA court has acquitted all 7 accused in July. Now, the victims' families say the court ignored crucial evidence linking the LML motorcycle to Pragya Thakur and failed to appreciate Purohit's admission of attending conspiracy meetings. Their appeal argues that the trial court relied too heavily on Thakur's uncorroborated claim that she had parted with the bike years before the blast. Debojeet, this case has courted controversy for years. From the NIA's U-turn to allegations of political interference, all eyes will now be on the Bombay High Court to see how it handles this appeal in the months ahead.
Next up, over in Bihar, the Patna High Court had strong words for the Bihar Prohibition and Excise Act. The court called it draconian, especially in how it allows for arbitrary seizure and confiscation of property. The facts of the case go like this. A man whose rented building was sealed, even though the liquor was allegedly recovered from a tenant of the same building, owned by the petitioner, in the present case had no knowledge of it. The court called it absurd, and the minimum fine of 1 lakh rupees is imposed regardless of whether it's 100 ml of liquor or just a few drops. The court ordered the immediate release of the house, calling the law's lack of proportionality. Is the law going to be struck down or is it going to be amended? Awstika?
So, in simple terms, the court said that the law gives officials too much unchecked power to seal, seize, and even auction a house without clear safeguards that can hit people who've done nothing wrong. The court used examples like rented flat, a joint family home, even a government quarter. Should all the owners suffer if they had no idea what was happening? They also called the flat 1 lakh minimum fine unfair because it doesn't care whether it's 100 ml or a huge haul, like you pointed out. But what does this mean for prohibition in Bihar? Is the law struck down now? Definitely not. The court was just making observations while deciding this one case. Since the validity of the act wasn't under challenge, these remarks are what we call obiter dicta, important guidance, but not a binding ruling that invalidates the law.
Thankfully, we do have some encouraging bit of news too, as the Telangana High Court took a firm stand for free speech, ruling that FIRs cannot be registered over political posts or speeches on social media unless there is a clear prima facie case. Justice N. Tukaramji issued guidelines to ensure prior legal opinion, and that prior legal opinion is obtained before lodging such FIRs, especially under serious charges like sedition or public mischief. In the case at hand, 3 FIRs were quashed against a man for posts critical of the Congress party, as none of the legal criteria for those charges were actually met. Awstika, can you please elaborate a little on what the court really underscored?
So what the Telangana High Court basically said is, don't rush to file FIRs over social media posts. Police first have to check if the complainant is even the right person or the aggrieved person to file it. Do a quick inquiry to see if any law is really broken and get legal advice from the public prosecutor in sensitive cases like you said. On political speech, the court was crystal clear. Criticism, even sharp or offensive, is protected under Article 19(1)(a). FIRs can only be filed if the speech crosses the line into incitement to violence or poses a real threat to public order. It also reminded the police that defamation is a non-cognizable offence. No direct FIRs, therefore, and only a magistrate can take it forward, and that routine arrests are not allowed, with Arnesh Kumar safeguards to be strictly followed. Debojeet, in my honest opinion, this is a very significant judgment because it comes at a time when we've seen a string of FIRs over social media posts from academicians like Ali Khan Mahmudabad to local activists, students, and even comedians. Commentators have said that such knee-jerk invocation of criminal law may have a chilling effect on free speech in the country. Therefore, the message sent by the Telangana High Court is very important, and it is this. Criticism of the government, however uncomfortable, is a constitutionally protected right, and criminal law cannot be used as a tool to stifle dissent.
Thank you so much, Awstika, for bringing so much legal clarity into what was honestly a pretty full week, in my opinion, in terms of important legal developments. That's all from us at LiveLaw this week. This is Advocate Awstika Das. I'm Debojeet Das, and we'll be looking forward to continuing this conversation next week with more updates from courts across the country.